HAMISH MCNICOL Last updated 0500, October 1, 2017. Offers of bitcoins and other digital tokens can be hard to classify under securities law. Most people would have heard of bitcoins, cryptocurrency and digital tokens, but few may realize how big a business raising capital with them has become. Even fewer probably realize the complicated nature of initial coin offerings ICOs, which so far this year have raised more than $2 billion and $2.77 and the legal uncertainty which surround them. New Zealand investors have definitely been involved in ICOs, but it is not clear whether anybody has ever done an ICO here. Minterellison Ridwat Senior Associate Andrew Sugate says there has been a surge of interest in ICOs in New Zealand. And while some overseas regulators have issued guidance on ICOs, China even went as far as to declare them illegal. New Zealand regulators have yet to explicitly comment on them. Read more. Palmerston North retiree makes a mint ditching gold for cryptocurrency. Cybercurrency exchange offers more than Bitcoin for New Zealand dollars. A beginner's guide to Bitcoin. What you need to know. Initial coin offerings ICOs have become big business after raising more than $2 billion in 2017. Minterellison Ridwat Senior Associate Andrew Sugate said interest in doing an ICO in New Zealand had surged, but how existing securities law applied to them was uncertain. It was therefore important to consider innovatively adapting our laws to ensure we uncovered this possible diamond from the rough, he said. It's just a question of how do we apply all of the old law and the old learnings from investment offerings onto that new framework and make sure that investors are protected, but that we don't kill an industry in New Zealand, and that we enable it to grow. It's important to be innovative and to look to the future. The law firm recently issued research on how the law might be applied to ICOs and digital tokens after it found the trickle of capital raisings overseas had become a torrent. An ICO was similar to an initial public offer IPO of shares in a company, but was different in that it offered digital tokens and that anybody could do one. Some companies had raised hundreds of millions of dollars doing them this year, while hoteliers and former reality star Paris Hilton and boxer Floyd Mayweather have both backed different offerings. Sugate said market commentary here only went as far as saying some forms of digital tokens could be considered financial products. The law here was that, if an offer of securities to investors fitted into one of 4 types of financial product, then it needed to comply with the regulations on disclosure required. But because digital tokens were a new technology, Sugate said some of the offerings looked like financial products, whereas others were harder to classify. The reason why it's difficult is because they're quite amorphous. The rules of the particular tokens that are being offered can be whatever whoever's coding it wants it to be. Broadly, there were 4 classes of tokens, including things like asset-backed tokens, which gave a digital right to an asset such as gold, as well as intrinsic tokens, which were not backed by an asset or promised any return, such as bitcoins. Sugate said he understood the Financial Markets Authority (FMA), which had the power to declare security a financial product, had been looking at the issue. An FMA spokesman said the regulator was working on a market update which it aimed to release in the next couple of months. This had followed discussions with businesses, law firms and advisors, and the FMA was supportive of innovation and fintech. The FMA's role is to ensure risks from new technology and products are appropriately mitigated. If anyone is currently considering launching an ICO in New Zealand, we encourage them to approach us directly to talk through their proposal. Sugate said guidance in this area was important because there were already cryptocurrency businesses in New Zealand, and the new technology was part of where financial services were headed. He suggested the FMA could look at running a licensed intermediary similar to peer-to-peer lending and equity crowdfunding, or to look at certain class exemptions. There had been some dodgy ICO offers, but the industry was starting to mature, he said. It's big business, it's growing, but it's operated, I guess, slightly under the radar. They're an advancement in technology, which can be used for good or bad purposes. But we should also be trying to think about how innovatively we adapt our laws, so that we don't kill the ability to do this type of thing in New Zealand. Sunday Star Times.